Good evening and buenas tardes. My name is Juan Arteaga and I am counsel to Bill Baer, the Assistant Attorney General for the United States Department of Justice's Antitrust Division. AAG Baer is unable to personally deliver his remarks this evening because weather-related travel issues prevented him from making it to San Diego. Thus, he has asked me to deliver his remarks on his behalf. AAG Baer apologizes for not being able to join you and hopes to have the opportunity to speak with you in the future. He also asked me to thank the National Asian American Coalition and its partners for sharing their views with us in the past about antitrust matters. He and the rest of us at the Antitrust Division value your input, and we look forward to hopefully meeting with your representatives next month in Washington, D.C. Now, on to AAG Baer's remarks. Congratulations to the National Asian American Coalition and its partners for organizing another successful conference. It is a privilege and honor to be speaking before a diverse audience with that includes so many community and religious leaders who have made it their mission to improve the lives of others. For almost 2 years now, I have headed the Justice Department's Antitrust Division. It has been a privilege to work for President Barack Obama and Attorney General Eric Holder. The Attorney General is often referred to as a lawyer for the American people. And I can assure you that Eric Holder has lived up to that challenging job description. He and the women and men of the United States Department of Justice are guided by the bedrock principle that all Americans must be treated equally under the law. As President Obama noted when he announced Attorney General Holder's resignation last month, the Justice Department has remained true to this principle during the 6 years that Attorney General Holder has led the department. Here are just a few of his many successes. Challenging several state laws that limited the ability of American citizens, in particular those living in minority and poor communities, to exercise their most fundamental constitutional and civil right, the right to vote. Working to overturn state immigration laws that would have subjected American citizens and lawful immigrants to illegal harassment simply because of the way they look or because of their last names. Leading the fight to protect and expand the rights of the LGBT community. Prosecuting a record number of hate cases and spreading the message that no one in America should be at risk because of the color of their skin, the person they love, the language they speak, the faith they practice, or the disabilities with which they live. Pushing for much-needed reforms within our criminal justice system, including supporting the law that eliminated the sentencing disparity for crack and powder cocaine offenses, calling for the adequate funding of public defender services, and promoting closer ties and better communication between law enforcement officials and the members of the communities that they protect and serve. Holding large institutions and their executives accountable for wrongdoing, irrespective of their wealth, power, or influence. Turning to my area, antitrust enforcement, Attorney General Holder has consistently supported the Antitrust Division's core mission of protecting American consumers by challenging conduct in transactions that attempt to restrict competition. Our first antitrust law, the Sherman Act, was passed in 1890 and sought to protect hardworking Americans from the harm that results when too much economic power is held by only a few corporations and individuals. This law became a vital tool under President Theodore Roosevelt, a progressive reformer often referred to as the trust buster. Speaking softly and carrying a big stick, Teddy Roosevelt challenged the largest corporations and most powerful men of his day, including the railroad monopoly owned by the influential Wall Street banker J.P. Morgan and John D. Rockefeller's Standard Oil Trust. Over the years, the Justice Department has continued Teddy Roosevelt's effort to ensure that competition works for the benefit of the American consumer. As a candidate, President Obama promised vigorous enforcement of our antitrust laws. We have made good on this promise. Here are just a few but powerful examples. Electronic books or otherwise known as ebooks, are a popular alternative to hard copy books. Because they cost less to produce, they should be cheaper. And until some point in 2010, they were. Suddenly, however, prices shot up in 2010. Why? Because certain book publishers and Apple entered into an illegal agreement to raise prices. The Justice Department sued Apple and the book publishers to put an end to their unlawful coordination. Now, what happened to ebooks prices when publishers and Apple were forced to compete? Prices for ebooks fell. In 2010, when the price-fixing conspiracy was in place, you often had to pay $12.99 or $14.99 for a bestseller. Today, a bestseller costs you on average about $8. But what about those who were victims of higher prices during the ebooks conspiracy? Our ebooks case has helped state attorney generals and private plaintiffs thus far secure $160 million in direct refunds to those who were wrongly forced to pay higher prices. These refunds did not require filling out any forms or jumping through any hoops. They were directly credited to consumers' accounts with Amazon, Barnes & Noble, and Apple. Sometimes proposed mergers between competitors put the American public at risk of higher prices through reduced competition. That was our concern a few years ago when AT&T wanted to buy its rival T-Mobile. AT&T claimed that by eliminating T-Mobile as a competitor, you, as a consumer, would be better off. Our job at the Antitrust Division is to kick the tires on those claims and make sure they are accurate before giving them credit in our work. Our investigation caused us to conclude that this claim did not hold up. Instead, the facts we uncovered told us that the elimination of T-Mobile as a competitor risked having you pay higher prices and receiving worse contract terms going forward. We and our colleagues at the Federal Communications Commission challenged the deal, and AT&T ended up abandoning it. And guess what happened next? Just like ebooks, when the antitrust laws are enforced, competition flourishes. T-Mobile went back to competing to win your business. It spent billions of dollars improving the products it offers. It fought to woo customers by offering lower prices and better services. And it gave customers freedom of choice by offering to pay the early termination fees for those who switched to T-Mobile. And T-Mobile's competitors were compelled to respond. Sprint began offering lower prices and better plans. AT&T targeted T-Mobile customers with a $200 credit, plus money for smartphone trade-ins if they switched to AT&T. T-Mobile responded by offering plans that allow customers to upgrade their phones twice a year. AT&T, Verizon, and Sprint all felt compelled to match these plans. Choice and competition in the airline industry are important too. This is why last year we challenged U.S. Airways' effort to acquire American Airlines. The settlement we obtained forced U.S. Airways and American Airlines to give up slots and gates at congested airports, including LAX, to low-cost airline carriers. Travelers to and from California have already seen the benefits from our efforts to protect competition. Virgin America now offers nonstop service from Dallas to Los Angeles and San Francisco through gates it acquired at Dallas Love Field. Southwest now offers connecting service from California cities to New York LaGuardia and Washington National using slots divested by American Airlines. Low-cost carriers, including Spirit and Allegiant, are using gates made available at LAX by our settlement to expand service to numerous cities. Finally, Spirit Airlines has announced it plans to use the gates it acquired at Chicago O'Hare to offer new nonstop service between Chicago and San Diego. At the Antitrust Division, we file criminal charges when you, your family, and your friends are victims of price fixing and bid rigging. In California alone, we have obtained 59 criminal convictions against real estate investors who rigged the bids on foreclosed homes being sold at public auctions. These scoundrels took advantage of homeowners who, as a result of the 2008 financial crisis, lost their homes. A foreclosed home is supposed to be sold at a public auction with the proceeds going to the bank and any remaining cash to the homeowner. By rigging the bids and lowering the prices paid at auction, these folks profited at the expense of homeowners, the banks, and U.S. taxpayers. And the wrongdoers are going to prison. Under the leadership of Attorney General Holder, we are prosecuting both companies and executives for antitrust misconduct. For example, a few years ago, we uncovered a massive worldwide conspiracy to fix the prices for a wide variety of automobile parts, including seat belts, airbags, and anti-lock brake systems. This illegal conduct made it more costly for companies like General Motors, Ford, and Toyota to manufacture cars, which in turn caused millions of Americans to pay higher prices for their cars. As of today, we have obtained criminal